Imagine waking up in the dead of night to the sound of breaking glass. Someone is breaking into your neighbor's home. You reach for your phone to call 911, but wait. There is no 911. There are no police officers patrolling the streets, no flashing lights, no sirens racing to the rescue. In fact, there's no organized police force at all. This wasn't a dystopian nightmare. This was everyday reality in colonial America. From the 1600s through the late 1700s, the American colonies operated without professional police departments. Yet somehow, communities survived, justice was administered, and order was maintained. But how? How did colonists deal with murderers, thieves, and criminals when there were no cops to call? Today, we're diving deep into the chaotic, often brutal and surprisingly creative world of colonial justice. Buckle up, because what you're about to discover might shock you. To understand crime and punishment in colonial America, we need to step back into a world vastly different from our own. When English settlers began establishing colonies along the eastern seaboard in the early 1600s, they brought with them centuries-old traditions of English law enforcement, but adapted them to the harsh realities of frontier life. In 17th and 18th century colonial America, there was no concept of a professional police force as we know it today. The very idea of paid, uniformed officers patrolling streets wouldn't emerge in America until the mid-1800s, when cities like Boston, 1838, and New York, 1845, established the first modern police departments. Before then, law enforcement was a patchwork system built on four main pillars: constables, night watches, sheriffs, and community self-policing. The constable system was the backbone of colonial law enforcement. Constables were typically appointed or elected by local communities and served part-time. They weren't professional crime fighters. They were ordinary citizens, often farmers, shopkeepers, or craftsmen, who took on law enforcement duties in addition to their regular occupations. A constable's responsibilities included serving warrants, collecting taxes, supervising the night watch, and bringing accused criminals before magistrates. Importantly, constables had no special training and received little to no pay for their services. The night watch, established in Boston as early as 1631, was America's first organized attempt at crime prevention. The watch consisted of volunteers and later reluctant draftees who patrolled streets from sunset to sunrise. Their primary duties were to call out the hours of the night, watch for fires, and raise an alarm if they witnessed crimes. The famous hue and cry system obligated all able-bodied men within earshot to respond to a watchman's call and assist in pursuing criminals. However, night watch duty was deeply unpopular. Wealthy colonists often paid substitutes to take their place, while those who couldn't afford it were stuck walking cold, dark streets looking for trouble. Sheriffs held the most authority in colonial law enforcement, particularly in rural areas. Inherited from the English system, the county sheriff was responsible for maintaining order across large geographic areas, managing jails, executing court orders, and organizing posses when serious crimes occurred. The sheriff could deputize ordinary citizens to form a posse, essentially a temporary law enforcement group, to pursue criminals or maintain order during emergencies. Community self-policing was perhaps the most significant aspect of colonial law enforcement. Everyone was expected to participate in maintaining order. If you witnessed a crime, you were legally obligated to raise the hue and cry and join the pursuit of criminals. Refusing to help could result in fines or punishment. This system worked because colonial communities were small, tight-knit, and deeply religious. Everyone knew everyone else, and social pressure was a powerful force for conformity. The colonial justice system was rooted in English common law but heavily influenced by religious doctrine, particularly in Puritan New England. Magistrates and justices of the peace, often the same men who held religious or political leadership roles, served as judges in local courts. They had broad discretionary power to determine guilt and punishment. There were no professional lawyers, no presumption of innocence until proven guilty, and trials were often swift and public. Crimes in colonial America fell into several categories. Religious offenses, blasphemy, working on the Sabbath, adultery, fornication, were prosecuted zealously, especially in Puritan colonies. Property crimes like theft, burglary, and livestock stealing were common and punished harshly. Violent crimes including murder, assault, and rape were relatively rare but dealt with severely. And moral offenses such as drunkenness, idleness, lying, and defaming another person's character could land you in the stocks. This was a world where justice was local, personal, and often harsh. The community itself was the police, the jury, and sometimes the executioner. As we'll see through specific historical examples, this system had both strengths and terrifying weaknesses. Let's bring colonial justice to life through real historical cases that reveal how this system actually worked, and sometimes failed spectacularly. Case Study 1. John Billington, America's first execution for murder, 1630. On September 30, 1630, a man named John Billington became the first person executed for murder in British North America. His story reveals both how criminal justice operated and how fragile social order was in early colonial settlements. John Billington had arrived at Plymouth Colony aboard the Mayflower in 1620. From the beginning, he was trouble. William Bradford, the colony's governor, described the Billington family as one of the profanest families in Plymouth. John and his sons frequently caused disturbances, challenged authority, and violated community norms. In one incident, Billington's teenage son was caught shooting firearms recklessly near Plymouth's gunpowder stores, an offense that could have destroyed the entire settlement. Despite his reputation, Billington remained part of the community for a decade. But in 1630, an old quarrel with a fellow colonist named John Newcomen turned deadly. The two men had been enemies for some time. Sources suggest disputes over land, insults, or personal grudges. In a moment of rage, Billington shot and killed Newcomen. With no police to investigate and no detective to gather evidence, the community itself became the investigative body. Witnesses came forward. The murder weapon was examined. Governor Bradford consulted with authorities in the nearby Massachusetts Bay Colony about how to proceed, as Plymouth had never dealt with a murder before. Billington was arrested by the constable and held in custody. A grand jury, made up of ordinary colonists, examined the evidence and indicted him for willful murder. A trial jury then heard the case. The proceedings were straightforward. Witnesses testified, the murder weapon was presented, and Billington himself apparently showed little remorse. The jury found him guilty. Governor Bradford wrote solemnly, "This as it was the first execution amongst them, so was it a matter of great sadness unto them." John Billington was hanged publicly, not just as punishment, but as a warning. Public executions served multiple purposes in colonial society. They satisfied the community's demand for justice, they theoretically deterred future criminals, and they reinforced the authority of the magistrates who held the colony together. Billington's case demonstrates how colonial justice worked when it functioned properly. The community investigated, ordinary citizens served as jurors, and magistrates applied the law. But it also shows the limitations. There was no professional investigation, no defense attorney, and no appeals process. Once the community decided you were guilty, your fate was sealed. Case Study 2. The Salem Witch Trials, When Justice Goes Horribly Wrong, 1692. Perhaps no event better illustrates the dangers of a justice system without checks and balances than the Salem Witch Trials of 1692. It began in January 1692, when several young girls in Salem Village, Massachusetts, began exhibiting strange behavior, convulsions, screaming fits, and trance-like states. A local doctor, unable to find a medical explanation, diagnosed them as bewitched. In a deeply religious Puritan community already anxious about threats from Native Americans, economic pressures, and religious divisions, This diagnosis ignited hysteria. The girls began accusing specific people of witchcraft. First came Tituba, an enslaved woman in the household of Reverend Samuel Parris. Then Sarah Good, a homeless beggar. Then Sarah Osborne, an elderly woman who rarely attended church. The accusations spread like wildfire. Here, where colonial justice failed catastrophically. Massachusetts Governor William Phips established a special court called the Court of Oyer and Terminer, meaning to hear and determine, specifically to try witchcraft cases. The court was composed of magistrates with no special legal training, driven by religious fervor and community panic. The trials violated nearly every principle we now consider fundamental to justice. There was no presumption of innocence. If you were accused and brought to trial, you were presumed guilty unless you could prove otherwise. The court admitted spectral evidence, testimony that the accused person's spirit or specter had appeared to the witness in dreams or visions. This meant people were convicted based on evidence that could not be verified, questioned, or disproved. The accused had no right to legal representation. Many were coerced into confessing through threats, isolation, and psychological pressure. Accused witches who confessed and implicated others were spared. Those who maintained their innocence were executed. This created a perverse incentive to lie and accuse others to save yourself. Between February 1692 and May 1693, more than 200 people were accused of witchcraft. 29 were convicted. 19 were hanged on Gallows Hill. One man, Gideon Corey, was pressed to death with heavy stones for refusing to enter a plea. 5 others died in prison awaiting trial. The accusations followed predictable patterns. Victims were often social outsiders, poor women, those who challenged authority, people involved in property disputes with their accusers. Martha Corey was a respected church member, but she had questioned the witch trials themselves, so she was accused and executed. Rebecca Nurse was a 71-year-old grandmother beloved in her community, but old grudges and property disputes led to her accusation and hanging despite passionate community defense. The trials finally ended when accusations began targeting increasingly prominent citizens, including the governor's wife. Suddenly, the magistrates realized the process had spiraled out of control. The Court of Oyer and Terminer was dissolved in October 1692, and a new superior court established with stricter evidence standards. The remaining accused were acquitted or pardoned. In 1697, the Massachusetts General Court declared a day of fasting and repentance for the tragedy. In 1702, the trials were officially declared unlawful. But for the 20 people executed and the hundreds whose lives were destroyed, justice came too late. The Salem Witch Trials revealed the darkest potential of colonial justice, a system where magistrates answered to no higher authority, where community hysteria could override reason, where there was no protection for the accused, and where innocent people could be executed based on the accusations of frightened children and vengeful neighbors. Case Study 3: Tarring and Feathering During the Stamp Act Crisis, 1765. Not all colonial justice came from courts and magistrates. Sometimes the community itself took matters into its own hands through vigilante action, and one of the most infamous methods was tarring and feathering. When the British Parliament passed the Stamp Act in 1765, requiring colonists to pay a tax on all printed materials, American colonists erupted in protest. They argued that Parliament had no right to tax them without representation in that body. No taxation without representation became the rallying cry. In Boston, anger focused on Andrew Oliver, the man appointed as the Massachusetts stamp distributor. On August 14, 1765, a mob gathered under the Liberty Tree, a large elm in Boston's South End. They hanged an effigy of Oliver from the tree, along with a large boot, symbolizing the Earl of Bute, who was blamed for the tax, with a devil emerging from it. As the day progressed, the crowd grew larger and angrier. They marched to Oliver's office building on the waterfront and demolished it. Then they moved to Oliver's home, where they destroyed his garden, broke windows, and ransacked the first floor. They then marched to nearby Fort Hill, where Oliver had recently built a new house, and tore it down completely. Throughout the night, the mob roamed Boston, terrifying officials and destroying property. 2 weeks later, on August 26, an even larger mob attacked the home of Lieutenant Governor Thomas Hutchinson. Hutchinson and his family barely escaped. The mob spent hours systematically destroying his house, one of the finest in Boston, breaking furniture, tearing down walls, destroying his library and irreplaceable historical documents, and stealing money and valuables. By dawn, the house was a shell. While these particular Boston mobs didn't tar and feather their victims, the practice became common during the Revolutionary period. Tarring and feathering involved coating a victim in hot pine tar, then covering them with feathers. Contrary to popular belief, the tar wasn't usually heated to temperatures that would cause fatal burns, but it was hot enough to be excruciating. Victims would then be paraded through town on a rail, subject to public humiliation, mockery, and sometimes physical abuse. Tax collectors, customs officials, and anyone perceived as loyal to the British Crown became targets. In 1774, John Malcolm, a Boston customs official and vocal loyalist, was tarred and feathered by a mob and forced to drink massive quantities of tea, mocking the Boston Tea Party. He barely survived and carried scars for the rest of his life. These acts weren't justice by any legal standard, they were mob violence. Yet they reveal how colonial Americans understood community enforcement of norms. When official channels seemed corrupted or imposed by distant authorities, the community took direct action. No constable stopped these mobs. No sheriff arrested the participants. In fact, many community leaders either participated or tacitly approved. John Adams, future president and defender of the rule of law, witnessed these events with horror. Though he opposed the Stamp Act, he was appalled by mob violence. He defended British soldiers after the Boston Massacre in 1770 precisely because he believed in lawful process over mob rule. But Adams was in the minority. Most colonists saw these extralegal actions as necessary responses to tyranny. Case Study 4: Theft and Public Humiliation in Colonial Connecticut. Not every crime ended in execution or mob violence. For minor offenses, colonial communities relied heavily on public shaming as both punishment and deterrent. In 1644, in Hartford, Connecticut, a woman named Mary Holt was convicted of theft. She had stolen clothing from a neighbor. The magistrates sentenced her to be placed in the stocks for 2 hours and then whipped. But there was more. She also had to wear a sign around her neck reading "Thief" whenever she appeared in public for 1 full year. The stocks were wooden devices that locked around a person's ankles and sometimes wrists, forcing them to sit or stand in a public square while townspeople walked by. Citizens were encouraged to mock, insult, and sometimes throw rotten food at those in the stocks. The humiliation was the punishment. Everyone in town would know what you did, and you'd carry that shame forever in a small, tight-knit community. The pillory was similar but even more severe. It locked around the neck and wrists, forcing the person to stand bent over. People in the pillory were completely helpless and subject to more serious physical abuse. Pillories were used for more serious crimes like perjury, forgery, blasphemy, and wife-beating. Public whipping was another common punishment. The convicted person would be tied to a post or whipping post in the town square and lashed with a whip or rod. The number of lashes varied based on the crime, usually between 10 and 40. These whippings were brutal, public spectacles attended by much of the community, including children. Branding was reserved for repeat offenders. Thieves might be branded with a T on the hand or forehead. Burglars received a B, adulterers got an A. Yes, like in the Scarlet Letter, which was based on actual colonial practice. These brands permanently marked you as a criminal, ensuring you could never escape your past. These punishments reveal several key aspects of colonial justice. It was public, it was physical, and it was designed to enforce social conformity. In small communities where everyone knew everyone, public shame was a powerful deterrent. Being marked as a criminal meant social ostracism, difficulty finding work, and permanent damage to your family's reputation. The colonial justice system had profound effects on the communities it governed, both positive and negative. Understanding these impacts helps us see why the system eventually had to evolve. Community cohesion and social control. In many ways, the colonial system strengthened community bonds. When everyone had responsibility for maintaining order, it created a sense of collective investment in public safety. The night watch, constables, and jury service meant ordinary citizens actively participated in governance. This wasn't abstract. Your neighbor might serve on the jury deciding your fate, creating powerful incentives for good behavior and conformity to community norms. Religious communities, particularly Puritan settlements, used the justice system to enforce moral conformity. Crimes against God, blasphemy, adultery, failing to attend church, working on Sunday, were prosecuted alongside theft and violence. This created an intensely regulated society where private behavior was subject to public scrutiny and punishment. While this promoted order, it also created a suffocating environment where deviation from narrow norms could destroy lives. The dark side of community justice. But the colonial system had serious flaws that led to injustice, cruelty, and abuse. The lack of formal legal protections meant that wealthy, well-connected colonists received far better treatment than the poor, enslaved people, or social outsiders. Magistrates had enormous discretionary power with few checks on their authority. They could set bail, determine punishments, and even alter established legal procedures based on their personal judgment. This created opportunities for favoritism, corruption, and arbitrary punishment. The system was also vulnerable to mob psychology and mass hysteria, as the Salem Witch Trials demonstrated so horrifically. When fear gripped a community, the justice system amplified rather than checked it. With no presumption of innocence, no professional legal defenders, and no appellate courts, innocent people had few protections. Public punishments, stocks, pillories, whippings, brandings, hangings, were intentionally brutal and dehumanizing. While they may have deterred some crime, they also normalized violence, destroyed individuals who might have been rehabilitated, and created permanent underclasses of branded criminals who could never reintegrate into society. Inequality and the system. The colonial justice system was deeply unequal. Native Americans, enslaved Africans, and free black people received harsher treatment and had virtually no access to legal protections available to white colonists. Women could not serve on juries, hold positions as constables or sheriffs, and face gender-specific crimes like scolding, talking back to your husband, or fornication, which was prosecuted far more often against women than men. In the southern colonies, slave patrols, groups of armed white men who policed enslaved populations, hunted runaways, and terrorized black communities, were a key part of law enforcement. These patrols had nothing to do with justice and everything to do with maintaining a brutal system of racial oppression. Why the system had to change? As colonial towns grew into cities, the informal, community-based system broke down. In larger populations, people no longer knew all their neighbors. The night watch proved inadequate for preventing crime in dense urban environments. Property crime increased with urbanization and growing wealth inequality. The weaknesses of the colonial system, arbitrary power of magistrates, vulnerability to mob justice, lack of professional investigation, unequal treatment, became increasingly intolerable. The revolutionary generation, having experienced British tyranny and mob violence, began developing constitutional protections. The right to legal counsel, protection against cruel and unusual punishment, the right to a speedy and public trial by an impartial jury, presumption of innocence. These rights weren't just abstract ideals, they were direct responses to the failures of the colonial justice system. The colonial approach to crime and justice might seem like ancient history, but its echoes resonate strongly in contemporary debates about policing, criminal justice, and community safety. The return of community policing. In recent decades, police departments across America have embraced community policing models that sound remarkably similar to colonial practices. The idea is simple. Police officers should be integrated into communities, know residents personally, and work collaboratively with citizens to solve problems and prevent crime rather than simply responding to 911 calls. Neighborhood watch programs, first popularized in the 1970s and 80s, explicitly rely on citizen participation in public safety, much like the Colonial Night Watch. Residents organize themselves to observe and report suspicious activity, working in partnership with police. These programs have shown some success in reducing property crime and increasing community cohesion. But the comparison also reveals troubling patterns. Just as colonial night watches and vigilante groups often targeted social outsiders, modern neighborhood watch programs have been criticized for racial profiling. The 2012 shooting of Trayvon Martin by neighborhood watch volunteer George Zimmerman sparked national outrage and revealed how community self-policing can go horribly wrong when it lacks oversight, training, and accountability. Vigilante justice in the modern era. While we'd like to think vigilante justice disappeared with the frontier, it persists in disturbing ways. Online doxing campaigns that expose alleged wrongdoers to public harassment are a digital form of the stocks and pillory. Cancel culture uses public shaming to enforce social norms, sometimes justly, sometimes not, in ways colonial Puritans would recognize. And in cases where communities feel police have failed them, some have taken matters into their own hands through street justice or mob violence. The dangers of unchecked authority. The Salem Witch Trials offer urgent lessons about what happens when judicial authority lacks checks and balances. The use of coerced confessions, unreliable testimony, and denial of legal representation that characterized Salem have all recurred in American history. From the Red Scare of the 1950s to controversial interrogation practices in the War on Terror. The trials remind us why constitutional protections matter. The presumption of innocence, the right to confront accusers, protection against self-incrimination, and the right to legal counsel aren't just bureaucratic niceties. They're essential safeguards against the abuse of power and mass hysteria. Modern criminal justice reform. Today's criminal justice reform movement addresses many issues that plagued colonial justice. Reformers argue that the system is still too harsh, too quick to punish rather than rehabilitate, and deeply unequal in how it treats different populations. The massive U.S. incarceration rate, racial disparities in sentencing, and the use of cash bail that punishes poverty are modern versions of colonial inequalities. Some reformers advocate for restorative justice approaches that sound surprisingly similar to certain colonial practices, bringing offenders, victims, and community members together to address harm and find solutions. But unlike colonial justice, modern restorative justice emphasizes healing, accountability, and rehabilitation rather than punishment and shame. The fundamental question, perhaps the most important lesson from colonial justice, is this: who should be responsible for public safety? The colonial answer, everyone, had both merits and grave dangers. Total community control risked mob rule, hysteria, and injustice. But our modern answer, specialized, professional police forces, has created its own problems. Militarization, us versus them mentality, lack of accountability, and sometimes brutal enforcement that traumatizes communities. The ideal might lie somewhere between colonial self-policing and modern police departments, a system that combines professional expertise and constitutional protections with genuine community participation, accountability, and shared responsibility for public safety. So, what have we learned about how crime was handled in colonial America without police? We've discovered a complex, often brutal system that placed law enforcement responsibility squarely on the community itself. Constables, night watches, sheriffs, and magistrates maintained a basic framework, but ordinary citizens did most of the heavy lifting, serving on juries, joining posses, responding to the hue and cry, and sometimes taking justice into their own hands. This system had real strengths. It created community investment in public safety. It made justice local and immediate rather than distant and impersonal. And in small, tight-knit communities where everyone knew everyone, social pressure effectively discouraged most crime. But the weaknesses were devastating. Without professional law enforcement, investigations were haphazard. Without legal protections for the accused, innocent people were convicted and executed. Without checks on magisterial power, authority could become tyrannical. Without consistent standards, justice varied wildly from place to place and person to person. And without protections for marginalized groups, the system became a tool of oppression. The cases we examine tell the full story. John Billington's execution showed the system at its most functional: community investigation, trial by jury, lawful punishment. The Salem Witch Trials showed it at its worst: mass hysteria, coerced confessions, executions of innocents. Tarring and feathering during the Stamp Act crisis revealed how easily community enforcement could slip into mob violence, and the countless cases of public shaming demonstrated how the system prioritized conformity and humiliation over rehabilitation. Could such a system work today? Almost certainly not, at least not in the same form. Our communities are larger, more diverse, and more mobile than colonial settlements. We can't all know our neighbors. We have professional law enforcement, constitutional protections, and legal standards that have evolved over centuries. Going backward would be disaster, but neither can we ignore the ways our current system fails us. Police militarization, mass incarceration, racial disparities, and the sometimes adversarial relationship between police and communities they serve suggest we haven't perfected justice either. Perhaps the answer lies in reclaiming some of the community investment and shared responsibility that characterized colonial justice, while preserving the constitutional protections and professional standards we've developed since then. Community policing done right. Restorative justice practices, greater citizen participation in oversight and accountability, and a recognition that public safety is everyone's responsibility, not just the police. Now it's your turn. What do you think? Could elements of colonial community-based justice work in the modern world? Are there lessons we should learn from this period, or should we be grateful we've moved beyond it? Have we gone too far in the opposite direction, creating a police state that's lost touch with communities? Share your thoughts in the comments below. And if you found this deep dive into history fascinating, hit that subscribe button and ring the bell for notifications, because we're just getting started exploring the strange, surprising, and often shocking truths about how justice has evolved in America. History isn't just about the past, it's about understanding how we got here and where we might go next. Thanks for watching, and I'll see you in the next video.